sorry to have kept you, but we have had the opportunity to read both the full judgment in Edinburgh, which you helpfully provided, and also, I've forgotten the initials anyway, the next case. And in my case, I have also read Smith and Trafford, which I'd read a long time ago, but haven't read in connection with this case. Annoyingly, I have left, I think, my notebook in my room. I might ask the usher just to go and. I think without making a do you have to go out? You have to go out that way, do you?
Yes.
Okay, I'll see you. We won't formally, if you don't mind. I'll just informally rise, have a word with the usher outside, and sort that out. What you sign? Yes, I won't take more than a minute. Sorry about that. Yes.
Well, before we move on from this point, we say we have to have a correct approach to both ECHR law, EU law, and our own national authorities. And once we have the ET grappled with this, hopelessly, didn't really, glossed over a number of the principles. So, just to finish off on Eggenberger, there may be, in some theoretical employment, an occupational requirement that you cannot believe that homosexuality is sinful.
Oh, I'm so sorry, but that's not what we're on, is it? It's your point's about freedom of expression.
Yes.
Nobody here is suggesting, I think, that he couldn't have that belief. It is that he shouldn't express it.
No.
Sorry,
I
didn't mean to.
Your question, this theoretical charity or something. But
No, yes, but my question, even about the theoretical charity, was about whether you could express those views, not whether you could have them.
Yes, but I mean, at the end of the day, that would be, provided there wasn't a requirement of employment of ideological conformity, it would not be permissible for a company director to have liberal views and be free to express them publicly, and an employee unable to express their Christian views. We'd say that would be direct discrimination. It's not very flexible, but that's what the Equality Act provides. So, and it's a harsh law, but that's how we would apply that. Before we move on from that, important to note, just in Eggenberger, that in that case, it was not just the fact that the directive bit, and in particular in that case it was Article 4, and they refer to the mandatory provisions actually of the Charter, and I think in paragraph 77, that the Charter is mandatory in its application. And of course, we'll be relying on Article 10 of the Charter, which parallels Article 9 of the Convention. It wasn't just that. The case raised practice and constitutional tradition of the German courts. And I'm sure the German courts and churches were just as outraged by this Luxembourg decision as we are on many occasions. But what the Luxembourg court said, you've got a presupposition, and that is that the court can have its own self-perception of who its members are. You can't have that. The court must do an independent review. And to make sure the charter rights and the directive rights are effective. So whether the tool of incorporation and the national settlement is irrelevant in that sense. The fact that Sweden and Ackerberger had was using its tax laws that predated EU laws, and that was their provision. Whether it's Eggenberger, where again these provisions date from the Weimar Constitution of 1919, predate, or whether it's our reasonable reason why, we've got to do a full reason why, and we can only do a full reason why until we understand the nuts and bolts of the convention. And just by sort of glossing at that bullet point there, of course, Edwida is the case in point. Edwida is the case where discrimination claims are rejected, whether there was indirect or whether it was direct. They were rejected, and it went to the European Court, and they discussed that in paragraphs 92, and they discussed the background, and they say, well, you've got, at least the Court of Appeal wrongly considered the convention, but the lower court, it's got to be considered at some point to make it correctly implemented. And one of the interesting points, in that case, is actually Miss Liddell's case, because she actually brought, in essence, the other parties brought a pure Article 9 case, but Miss Liddell brought an Article 14 case, that she was being discriminated in her rights by British anti-discrimination legislation. And that is a rather telling sign where we've come to. But in that, the European Court said there wasn't the correct proportionality analysis. It did apply to the workplace, Article 9, and we didn't do that previously. Secondly, the belief that marriage is between a man and a woman is protected by Article 9. And thirdly, the correct comparator is someone of no claim.
I'm getting rather lot. What's all this going to?
Well, that's going to the point we need to get the convention right, and we need to apply it correctly. And
I'm sure, obviously, that's so.
Well, just before we move, you said you've looked at Smith. If I could just do Smith and Livingstone with lightning speed. That's 16.
Yes.
Well, the highlighted paragraphs 62 to 64 of the judgment, those are the ones that are quoted in the skeleton. And if you see it, paragraph...
you're talking about Smith?
Smith, yes. Paragraph, I got that...
Yes, it's fine. You said highlighted. They weren't highlighted.
No, sorry. When I said highlighted, they're referred in the skeleton.
Referred to in your skeleton, yes.
Yeah. And just saying, 62, I cannot envisage how any such loss of reputation would arise in the mind of any reasonable reader of Mrs. Smith's postings. Goes on to discuss that, religious and political. And then 63. moderate expression of his particular view of gay marriage in church. And 64, for these reasons, I've come without difficult conclusion about gay marriage in church were not such as did or could bring the trust into disrepute. Again, that's reinforced at 66, when he talks about halfway down, paragraph 66, the right of the individual to freedom of expression, freedom of belief, general entitled to promote their religious or political belief, provided they do so lawfully. That's the criteria. And
well, you need the next sentence, don't you? Or we ought to be referred to the next sentence.
Of course, an employment legitimate permits it work when a work-related contact, but it would be prima facie surprising if an employer had, by the incorporation of code of conduct into the employee's contract, extended that project into personal social life. But even, I mean, that's drawing a division between social life and work life, but even a regulation at work, whether an employer could, for example, ban all religious conversations or all conversations on Liverpool, I'll leave it to another day, but that case may come up. But and just 72, he talks about various freedoms that you're entitled to, and 82, the lawful and frank exchange of political and religious views. I mean, it's a classic case of an employer overreach. We don't like your views. We say that LGBT people will be fearful of using housing stock in the Trafford Housing Association. We are invoking a penalty on you. We say that's on point. The other case I'd like to take to is tab 9. It's not particularly on point, but it's an interesting one.
Well, hang on.
Well,
I will allow you some to say it's not particularly on point, but it's interesting. That's what we're here for. This is not a general essay on the law of...
No, I'm understating my position. And again, I'll be lightning speed. This is Ken Livingstone's adjudication panel. We all know this case. It's where he verbally abused a Jewish reporter as a Nazi guard and blah, blah. And he was referred to the adjudication panel. The points I just want to go is, I think it's 36 to 38 of Collins J's decisions. The first thing is 35, just to sort of focus on that point, paragraph 35 of 164, where he says, I have no doubt the appellant was not to be regarded as expressing a political opinion which attracts a high level of protection. He was indulging in offensive abuse of a journalist whom he regarded as carrying out his newspaper's behalf activities which the appellant regarded as appalling. Nevertheless, as Mr. Moorhead accepted, Article 10 applied. Everyone is entitled to say what he likes, provided he does not act unlawfully and so commits an offence, for example, under the Public Order Act. Surprisingly, it may appear to some the right of freedom of expression does extend to abuse. And then he says freedom of expression is a trump card. And then at 37, if I may just jump to that paragraph, as I am moving at lightning speed, he goes on, I do not accept the reasoning set up in paragraph 68 of the adjudication panel. The appellant had ceased to act in his official capacity as host of the reception and was leaving the building to go home. He was accosted outside the building, but it does not seem to me to be a matter when he was, it does not seem to me to matter when he was approached. It might have been when he reached the front door, his front door. So he goes on there to essentially say the minute he left the public meeting at the Mansion House, he was no longer the Mayor of London, he was a private individual entitled to heap abuse on a journalist. It may bring opprobrium on Mr. Livingstone, but it's not within his functions of the Mayor of London. So we say there is a body of domestic law, we don't even have to go that far to the European Court, in which the clear rights of free speech are demarked very sharply and are extensive. And, my lord, that is how it should be, and that's what we're going to be, that's what we are arguing for in this case, because it's to the consequence of otherwise that you could lose perhaps your job or ultimately your council house or whatever your privilege is by expressing political views and opinions or religious views and opinions which those who employ you don't like or people don't like would be the end of freedom in Britain.
I imagine you would say that the fact that this was a non-executive board position doesn't make any difference. It would be the same if he was an employee of the trust.
Well, obviously, it's all factual. And
yes, but I mean, in general.
Yes.
In general, the fact that this was your client being, as I think he explained, in retirement doing public service shouldn't be treated as a distinction if he'd been a man in his early career and dependent upon this job.
No, they shouldn't be
the same principles.
This is a principle because people are involved in politics. People have menial jobs, become Labour candidates. People are executives, perhaps become Conservative candidates. And we don't want people's political, religious, and private activities. There is a limited scope to the employer's interest. And then
yes, the distinction, I think you followed me, but the distinction I was drawing was between, as it were, it was their livelihood in the sense that...
I don't think that's a criteria of livelihood. No. I mean, obviously, many of the cases we have looked at, like Negoni, were livelihood.
Yes.
And I think Smith was a great threat to his livelihood. But I don't think, though, that's the criteria. The criteria was, if there perhaps was harassment in the workplace, that would be in the interest of the employer. So we simply say, regarding these developments, whether it's Vulcan, Germany, or, I'm going to pronounce that wrong, or whether in European court law, or whether it's the Charter of Article 9, which requires the consideration of Article 9 and an application of Article 9, or whether it's through the prism of our own national law, what is absolutely clear is that what Mr. Page did was lawful. And then that raises the next question in this case. And I ought to say, before I move on, I mean, Mr. Page is very analogous to Mr. Smith, is that their comments were actually fairly modest and moderate on a sensitive subject. They weren't like some of the other individuals, like Mr. Livingstone and Mr. Boo-Boo, who let the person have it, and actually were insulting, the truth be said. I would actually, Article 10 could probably be drawn at the line of insult. But it was not drawn at the line of expression of religious belief in a modest, reasonable fashion. So when we get to that stage, when we get to the stage where we know these parameters and they have to be applied, we say EU law is mandatory, conventional, well, we strive to comply with our international obligations of an incorporated treaty. When we get to that, we have to look at the reason why. And if you haven't got that right, you ain't going to get the reason why right. And they ain't got that right at all. I mean, they gloss over all these fundamental principles as if they're meaningless, and Article 9 doesn't apply to speaking religious talks on a TV show. Well, that requires some analysis, and there are lots of religious TV show cases in the European Court. They gloss over all of it. They don't even address Article 10. They say it adds nothing to it. I think Bobo was the case referred to. Adds nothing to it. They don't analyse it. And it's one thing to analyse it wrong. It is another thing not even to analyse it. And that's what we say took place. And then when we come to the reason why, it's extremely unclear, as we've already discussed in the morning, what exactly were their reasoning. it's scattered throughout the judgment and then summarised by this Justice Choudhury in the EAT as including 5 broad points. And
So you say 5 points. I expect you're right. I only noticed 3, but what
well,
the passage?
Yes, if I may take you to 216, if I may, of the skeleton argument, page 216 of the skeleton. Let me just read that.
Oh. Which paragraph? Which paragraph? I've got page 216. Which paragraph are you taking?
Paragraph 47 at the bottom. Then I quote in parenthetically EAT. The EAT summarising of the ET's factual findings, and then they're very helpfully numbered. Respondent acted as he did.
Well, this is you're paying yourself a compliment here.
Well, I'm not even doing myself a compliment. I didn't have the brain power for that breakdown, but I was assisted. But I am
well,
paying
I'm
myself
not.
a
Well,
compliment.
anyway, it doesn't really matter. But I mean,
nobody else is, my lord. So forgive me.
Well, it may or may not matter, but I think we should just be accurate about this. I am not at the moment sure that 2 and 3, your Little Roman 2 and your Little Roman 3 are separate.
Well, that's correct. See, and I think if you go to paragraph 48, there's a breakdown of it. Those are what he said, and then they do seem to be rather similar. But so there's a sort of an attempt to sort of deal with what he's saying and put the analysis on it.
I'm also not sure that 4 and 5 are separate. Right. That's more debatable, I think. But 4, the fact that his actions were clearly in conflict with the protection of health, which is the trust and response principle function, that would be very hard to understand, except unless what you've called 5 is intended to be an explanation of that. Perhaps the word "and" is not very helpful, because I mean, you come back on me if you think this is wrong, but I think 4 and 5 are a single point, which is that people who didn't agree with his views expressed, who are likely therefore to be homosexuals, that might not only be that, would be put off, or there was a risk they would be put off, from seeking the services of the mental health services of the trust on the basis that a member of the board of the trust had such views. Well, that's the point being made at 4 and 5, isn't it?
It is the point made at 4 and 5, but of course that was the point made in numerous other cases and can be made in many, many more cases.
Well, I don't understand what you mean by that.
Well, it was the point made in Smith. And it was
no, well, Smith wasn't about this at all. Smith was about offending your fellow employees.
No, there was also parts in there, I believe, in the judgment. I'd have to dig it out, but I could do that. The LGBT individuals would be fearful of using housing stock.
Yes, I see, but you have said that before, and I'm sure you're right. I noticed that as I was going through. But suppose that is the case, that would be a different factual situation. The judge would be perfectly entitled to say that was just fanciful, but they might not say the same here. This is very different from that situation.
Well, I don't think it is. It's an assertion being made to close down a viewpoint.
But it might be a correct assertion.
Well, to be honest, even if it was a correct assertion, that would be a matter for full necessary democratic society review. And in our submission, that would be an argument that would be unlikely to prevail. because of obviously the wide-ranging implications of such an argument. It would have to be at least cogently proved with substantive evidence.
What did the EAT say about that particular
Well,
point? Was that particular point made to them?
Well, I think they address it in paragraph 57. In a slightly scattergun approach.
There isn't a 57.
Is that
The E80.
Oh, E80. I don't know if they do address that.
Well, maybe because the point wasn't made to them. What I understand you to be saying is that there was no sufficient analysis of the assertion that potential recipients of the trust services would be put off by hearing that one of the directors of the trust had these views. I'm just wondering whether you made that. I don't remember that in your grounds of appeal to the EAT, and I don't remember the EAT.
If it helps, that paragraph 41, the EAT refers to the fact that there was mention of Article 10 rights in the skeleton argument, but those arguments were not developed in oral submissions, and it would appear that a similar stance in respect of Article 10 was taken below in the ET. And then there's a reference to paragraph 60 of the ET's decision. No clear argument based on Article 10 was developed during the hearing or in the claimant's written closing or in oral submissions or in the supplementary written submissions presented after the conclusion of the hearing.
The Employment Tribunal, though, very helpfully produced at page
Yes, this wasn't you in the Employment Tribunal. It was Mr. Stroilov, wasn't it?
There was considerable discussion of cases of authority, and I think it's 12 of the. 35, page 12 of the actual Employment Tribunal judgment, there's a very helpful list of cases that were considered, and
301.
And they address the whole spectrum of manifestations of belief, speech, action.
They're not really Article 10 cases, they're Article 9, if anything.
Well, to the extent that some of the cases involve religious speech, and I think that is a facet. The second case, Medway came up, but some of the cases, like core issues trust, was an Article 10 case.
Fuentes Bobo is an Article 10 case.
Yeah. And that is actually referred to at paragraph 60. The ET say no clear argument based on Fuentes Bobo was developed.
Well, I think what we say to that is whether Negoli is religious speech under Article 9, or whether it's taken under Article 10, or whether it's Article 10, it's not. They're not hermetically sealed. The issues are the same, whether it's speech or religious speech, or whether Article 9 or Article 10 are the lex specialis. Those are matters for the court to address. But what we do say is there's been enough mention of European law authorities in these cases, which have been considered and rejected. But it still becomes a point of law whether the balance is correct. If you are going to make an assertion that free speech can be silenced because we would submit a speculative concern over a very small part of the community, that would require a full rehearing and a full question to be addressed. It would have to come up on those points, and it would come up on those points.
Not sure a very small part of the community can remain hanging in the air unconsidered. There's a trust area of some millions of people. We're probably talking about some hundreds of thousands.
Well, I hear what you say, my lord. And
the fact that, I mean, it's a minority. Your client's in a minority. They're in a minority.
Yeah, and I think, you know, we don't want to disparage any group or anything like that.
Well, I'm only on a couple of occasions picking you up on what appear to be as if maybe you're describing things that we must all agree with.
No, we're not. But the free speech, as Mr. Justice Collins said in Livingstone, is the trump card, and I hear it.
I'm only picking you up on your free speech, which in this case seemed to me inaccurate.
Okay, I accept that. I apologise. So we say they failed to do. We're not very sure which is the lex specialis, whether it's Article 9 religious speech or free speech, but they haven't done a proper analysis. They've dismissed it. They simply say it's not engaged Article 9, doesn't include appearing on shows and discussing your views. And Article 10, where there's one case, but it's not developed enough, maybe, you know, possibly in the skeleton, but some of the other authorities were there, but we don't think it adds anything, is really what they said. So we're...
Can I just... Sorry, I didn't mean to interrupt you.
No, please do.
Can we just look again at paragraph 57, which you described as a scattergun approach? And so it's page 318 of the bundle. That's 57 of the Employment Tribunal's decision. I'm sorry.
Oh, yeah, I think I mean...
Yeah, it's my fault. I didn't say what I had in mind. Do you have that?
Is 57 of the ET or the EATs?
ET, page 318.
318. Yes.
Half a dozen lines up from the end, having referred to the fact there was evidence of a concern on the part of the trust about what Mr. Page had done on the trust's ability to serve the entire community in its catchment area. In context, that means the LGBT community. The tribunal makes this finding: given the claimant's high-profile role within the trust, the tribunal finds that this concern was justified. Now, that is a finding of fact. It could, in principle, be challenged on the basis that it was perverse, but I haven't identified any such challenge either in your appeal to the EAT or your appeal from the EAT to this court. Now, I could be wrong about that, but I just wanted to check.
Well, perversity challenges are extremely, in my experience, unprofitable. But
Not necessarily, no. But in any event, whether they're unprofitable or not, I just was trying to check out whether they were made.
I don't believe they were made. But,
No, I don't think so either.
but given the claimant's high-profile role within the trust, that's actually a decision by the tribunal that his rights are limited because of his high-profile role. And I say that I would submit that's a point of law.
Well, that's a different point. There could be a point of law about whether, even if they had a justified concern about that, that trumped his free speech rights. But I'm at the prior stage of actually finding whether there was a justified concern that homosexual people might be put off from
Well,
seeking the assistance of the trust,
well, our submission on
and that isn't challenged.
but it is challenged.
Where's it? Well, I thought you just
it's not
agreed it
challenged on
wasn't.
perversity. It's
Well, it's the only ground on which it could be challenged.
well,
Is it?
that particular passage, but our position,
Well, that's the passage I'm asking you about.
well, we haven't challenged that passage on perversity, but we say, if we actually, if I may, perhaps return to the skeleton, when you break down what the EAT's assessment of the findings of fact really were, and they're not clear findings of fact, and they don't address all the issues, and they don't even address this issue accurately or appropriately. There's only, paragraph 50, looking behind the EAT's summary, that's at page 217, but looking behind the EAT's summary of the original ET judgment, does not clarify these issues.
So sorry, which page are you reading from?
217.
270.
217.
217.
Sorry, 317.
217. So, excuse me.
Are you looking at the
No,
Employment Tribunal judgment?
No, I think
that's
Mr.
the
Dammon's
skeleton.
now moving on to his skeleton argument, or
I
moving
see.
back to his
I beg your
skeleton.
pardon.
Which paragraph on 217?
50. And looking behind the EAT summary at the original ET judgment does not clarify those issues either. Only two proper reasons are identified. The appellant's media interviews, and they're not defined, just media interviews, and much less significantly, his failure to warn the trust about it. All the other points made by media are parasitic. So, whichever way, so in 51, we say, given the broad terms in which the ET findings are set out, there is no basis for the EAT's assertion in paragraph 33 that all of those matters answer the reason why question, which the trial was required to ask itself. None of them were found to relate to the claimant's religious belief. Well, the reason why question is deeply complex, and because of the inadequacy of it, you can see there's a discussion of some of the evidence and the focus of the evidence. And what it shows in this is that it's what he said. That's why the LGBT community were concerned. That's why people made objections. It's not because he was on. They haven't analysed fully the reason why, and they haven't addressed the expression, we say, of his religious belief on those shows. And that not only raises a domestic law issue, but we say interpreted by the cases we say. And that's...
Can you just help me? You've reminded me of something I meant to ask you this morning. I think in the magistracy case, but in both, probably in both, you put your case in domestic law, both on the basis of a religious belief, but also, if necessary, of a philosophical and whatever the correct language is. That's not obviously directly relevant to victimisation, but in the lower stages of the case, when discrimination was an issue, it was. Am I right in thinking that Article 9 isn't as wide as philosophical belief? There are some things which would be protected in the domestic discrimination legislation which aren't protected by Article 9. Suppose this was the position, suppose your client had exactly the views he has about same-sex adoption, but not as a result of any Christian belief. They were just, suppose he was atheist or agnostic, but had the same views. That wouldn't be protected under the convention, would it?
well, it would, because it protects religion, thought, and conscience.
I see that.
But
I'm just asking for
no,
instruction.
it also
There's equivalent case law, is there?
there is.
Yes, I see. Okay, well that's
There
the
is
answer
religion
then.
and belief. But I think, to be fair, there has been a slightly recent years, a sort of heightened protection of religious rights in recent years, as opposed to sort of secular rights, which are slightly more difficult to define, if I can put it that way. I mean, at least there's a textbook and a tradition and a culture.
No, well, of course, that's a problem you
Yeah.
have in domestic law as well.
Yeah.
Okay, thank you.
Yeah.
I'm grateful for that.
Yeah.
Go
So
back to where you
While
were.
we're looking at 217, could I just ask you about 48D? Linking 48D with 50, which you were at a moment ago, you say only 2 proper reasons are identified. I thought we'd rather boiled down the discussion earlier on to say that there were sort of 3 reasons. One was going public. 2 was not telling your employer about it first. And 3 was, as it were, the impact on community. Now, you're arguing here that number 3 is not a reason. Is that it?
I don't think we're saying number 3 impact's not a reason. We're saying it's parasitic on the fact you went public. There wouldn't be an impact if you hadn't said
Well,
so.
focusing then on 3, just for the point that I wanted to put to you. We have to be careful, don't we, not to present this in terms, as it sometimes come out, as if in some sense there's an oppositional dichotomy between people with sincerely held religious beliefs and a section of the community, in this case, the LGBT community, because that's not what the tribunals actually found. They said there is a part of the community, the LGBT part, which has a history of non-engagement with services which we wish to overcome. But it's right, isn't it, that I mean there can be plenty of people who are not part directly of the LGBT community who would equally take objection or be caused offence at the thought of a person holding certain views being in a management position within the trust. Likewise, there may be people who are within the LGBT community who support or strongly identify with a point of view such as held by your client, namely that they might themselves be homosexual, but they might not support homosexual adoption or something of that kind. So one should be careful, shouldn't one, before saying it's on this side, this group, on that side, that group.
No, well, I think that's an unfortunate development of the last 10 years, if I could put it that way. This sort of
Would you push back, as it were, against my suggestion that one can't identify necessarily points of view with particular groups?
No, I don't think that's true. I mean, there'd be many Christians who support the LGBT agenda, and there'd be many LGBT individuals who just want a private life and believe in free speech. And it's been an unfortunate development. But this case is slightly wider. I mean, it's gone down the track because, no doubt, there are active participants in these issues. But this case is wider. It's someone having a job in a senior position who's done a lot of good service, got a lot of skills to offer, and has expressed a view that some people object to, and that's resulted in the termination of a position. And that is the wider question in this case. It happens to fall again on the protagonists, and that may be unfortunate. It would be better that, I don't know, business stops someone running as a Labour councillor or something, or some case of that nature, because they had special clientele. But so that's why we say this case does raise wider issues. I mean, as far as Mr. Page is concerned, it is an Article 9 issue because he voiced his religious beliefs and he's suffering quite greatly for it, and that's a land of religious freedom has got to, obviously there are bounds. I mean, because some Islamists say jihad is good or eating babies is sort of my religion. There's criminal law bounds to it, but in this case, it's the simple modest expression of a religious viewpoint, having very draconian
I don't think that was the most sensitive choice of examples, but
No, well, I was. Obviously, there are limits to this. I mean, people say, what are the limits? There are limits to this in a liberal society, but normally the limits are encompassed by the criminal law.
well, I think we're getting rather a long way away from the issues in this case, the legal issues.
Well,
We started, I think, with the discussion of direct discrimination. We've had a considerable debate about Article 10, which, of course, as we've already established, isn't directly enforceable, but only in the Employment Tribunal, but simply may impact the correct interpretation of issues of domestic law. But have you said what you need to say about direct discrimination?
well, I think I'd just refer you at this stage to the skeleton. I won't, it's quite long, 219 through to 221, where it discusses the shortfalls of the Employment Tribunal's analysis.
Well, I mean, I don't want to stop you making any proper point you want to make, but I just want to keep us on focus.
Yes. Well, we say that they should have considered this, they should have seriously considered the distinction between the reasons and motives. We say it's very clear in this case. The concerns about possible misinterpretation about what was said or potential impact on the LGBT community, we say are not freestanding reasons. They're motives for objecting to a public expression of the applicant's beliefs. And the true reason must be, and it logically must be, Mr. Page's very public expression of his religious beliefs. And we don't believe that analysis is inconsistent with the reasoning of the ET or the EAT. It's just there's a serious failure by the ET to identify the reason why with sufficient and relevant reasoning as required, and therefore sufficient clarity on their basis of their decision, in particular distinguishing reason from motive. And then in the paragraphs, I address some of the obvious failings. We say, it says that they overlooked obviously the convention rights. They refer, the only reference they make to manner seems to be he went public and he should have expressed his views discreetly. We say that would raise articles under Article 10. You can raise your views publicly or discreetly. That's not the operation of Sections 3 and 6 of the Human Rights Act. It cannot be that Mr. Page was removed from his position simply because he gave a media interview. It's logical, whatever he said, it's logical and it's quite clear, and this needed to be addressed by the ET, that what worried the respondents, and what the respondents thought worried the LGBT community, was Mr. Page's beliefs. And therefore, the respondent's reaction is linked clearly and indissociably from the protected characteristic in issue, which is done an analysis with a comparator, and then compared if someone had actually, instead of just focusing purely on the reason why, but actually brought a comparator in, they would have then quickly realised that if someone had, in the management, gave a pro-LGB talk on the radio, it was unlikely that any action or detriment would have been taken. So that is what we say on direct discrimination.
That's not the other side of the same coin. Giving a pro-LGBT talk. What do you mean by that?
Well, I think what...
If you mean saying that LGBT people should be preferred to other people, then that might be the other side of the same coin. But if you are simply saying they should get a fair crack of the whip, then that's not the other side of the same coin.
Well, I mean, what Mr. Richard Page did, if I could put it in that kind of, forgive me, he came out as a Christian. This is what I am, this is what I believe, and no one liked it very much. So the comparator would be someone coming out as gay, and that having a repercussion.
I think we've slightly shifted ground. But anyhow, there it is.
No, well, I think what I'm suggesting is that if you select the correct comparator...
yes, your comparator is the LGBT person who comes along and says, I think that services should be prioritised in our direction to the expense, for example, of devout Christians.
I don't think I'm saying that, because I don't think Mr. Page ever said that.
No, that's Lord's point.
Yeah.
That's my point.
Yeah.
Yeah,
Well,
right.
well, I mean, I'm obviously misunderstood that, but if that wouldn't be the correct comparator. That wouldn't be the correct comparator. But that's why sometimes the arid search for a comparator does produce profit and fruit, and that there is a question of which is the correct comparator. But what clearly it would have done, it would have added to a very deep... The trouble with religion is they've lumped in a lifestyle, complex, individualistic practice with immutable characteristics like race and sex. And there is difficulties in giving straight comparisons, but it's an exercise that's worthwhile doing in such a sensitive and complex area. On the victimisation point, that is covered again. It's paralleling Lord Chancellor to a large extent, but one of the and that's 221. But one of the contrasts in this is that in the Lord Chancellor's case, of course, there was a very specific BBC interview on the 12th of March 2015. Again, this case suffers from a failure to identify which particular interview that the respondent objected to. It's all very, very, very general. And we say, in any event, to the extent, as in Lord Chancellor's case, this is covered by section 27(2)(d), and it's clearly the expression of his religious belief, whichever forum that was in, the manifestation of his religion, that was the cause of the action. That is not separation of able to separate, and indeed, again, the analysis of the ET is woefully inadequate. It just says we've decided this, let's knock everything out. And then finally, the indirect discrimination claim. It might be useful just to remind ourselves what the bus.
Well, it might in a minute, but I would just like to know before we go to the authorities what your submission is. I think I saw in Mr. Criddle's skeleton argument, and I neglected to follow it up. Would you just give me a moment? A statement, yes, she says at paragraph 50 of her skeleton, cross-referring to well, she gives a cross-reference to page 226. I haven't quite. Oh, I see. Yes. You forgive me. You say at paragraph 91 of your skeleton. Or rather, Andrew Storch, solicitors. Is this so you were? I hadn't picked this up when you were rather coyly disavowing having put all those clever breakdowns into the the EAT judgment 33. You were saying it wasn't you. This actually isn't your skeleton, is that right? I mean, you're speaking to it, but
well, I'm speaking to it. I mean, it's based on previous work we've done together, but I didn't.
You didn't feel anyway. It's not okay. I just want to know how to.
Yeah.
But is it fair to say you are You do not want to take responsibility for it when it was submitted. That's why you didn't sign it.
I think I was just aware at the time or something.
Oh, I see. So we can treat this as your skeleton.
Yeah. Yes.
Oh, I'm sorry. Right. Okay. Well, that's what puzzled me.
Yeah.
Okay. Right. Well, we've got over that. But paragraph 91 of what I will now call your skeleton says the submission that the test of group disadvantage does not apply at all where convention rights are involved is no longer pursued in this appeal. But you go on to make a point that that you are still pursuing what's called the alternative submission, that the evidential hurdle is low.
Yeah.
Doesn't Mbar only go to the point that you've now abandoned, or have I misunderstood it?
Well, it doesn't go fully to the point, and it's three judges going three different ways, which is part of the confusion of it.
Well, I thought there was a clear 2-to-1 split, but maybe not. Well, you must take us to Mbar if you want, but I just wanted to be clear what we're now arguing about, given that concession.
We're now arguing, the argument is that we see that there's a marrying up of Article 9 with the various discrimination provisions. Mbar sought to engage in that process. We say in that case that Miss Morris Case says it's obvious, it's clear, I don't even need any evidence that some Christians are Sabbatarian. Lord Justice Voss says Article 9 has no, and the regulation at the time has no requirement, Article 9 has no requirement for group discrimination, and we can simply interpret indirect discrimination to include the soul.
Well, perhaps we better look at bar. At the
Yeah.
moment, I'm not following you, but I expect I will when we have the package in front. Remind it's in bundle 2, behind tab 9.
Bundle 3.
Is it?
19, I think it's 2.
19.
Oh, I'm going mad.
19.
It is bundle 2. Did I say 19? I'm so sorry. Yes, I see what's happened. I see what's happened. Yes, right. Yes. Anyway.
I'm the one now. Well, it may have been a concession too far, but the position was the low evidential threshold for group discrimination in this case. And it may well be it's an unnecessary concession, it should be withdrawn, but what we focus on, as you know, this was a lady who was Sabbatarian, and there was a discussion whether it's quantitative or qualitative that we should take on board, and clearly the quantitative equation is relevant. There may be instances where banning kosher or halal food would have widespread implications.
Sorry, where are you reading from?
I'm not reading from anywhere, I'm just making a submission, but
Well, I would be assisted certainly by an analysis of exactly what the reasoning was of the 3 members of the court on the point that is important to your submission.
Yes. Well, if we go to paragraph 12, Lord Justice Morris Kay refers to Williamson, and it's not for the court to investigate people's beliefs, and as long as it's sincere, we accept it. He then quotes from Bishop Nazar Ali. There's a little part under the quote. The first part of that passage, individual fact-finding stage, presents no problem in the present case. Everybody accepts the claim is about Christian with sincere Sabbatarian beliefs, nor is the evidence of the Bishop Ali disputed. Some Christians will work on Sunday, others won't. It is obvious that some Christians have no such inhibition. And it's a word of the use obvious. There's a quote from Nazar Ali, but it's fairly obvious.
So sorry, I've lost you. Which paragraph are you on?
After quotes at 13, he quotes Williamson. And then at the bottom, there's an unnumbered few lines.
Yes, I see. Thank you.
Yeah.
I've got it now. Yes, so sorry.
And then he quotes from Lord Justice Ricks the problems of identifying religion and articles of faith and courts engaging, and he quotes Lord Justice Ricks, who says 3 or 4 lines down, I am concerned that a secular court is ill-equipped for such distractions. I am concerned that it's not only ill-equipped, but it lacks, in this case, the conventional means by which it would normally proceed to make such distinctions, which is evidence. I am in the event uneasy about the efficacy of such evidence. One of the problems of religion is the diversity of beliefs, even under the umbrella of a single faith. Then, if we may jump to paragraph 17, Lord Justice Morris Kay addresses one of the problems in this case, the question of group discrimination, which comes up, and it's very undefined what it means, and some judges seem to require sort of virtual reports, and other judges accept. And he goes,
It's perfectly clear what it means. It's a requirement of the Act, or in this case, the regulations. Just this is
yes, but if you go halfway down, well, that's why we're saying it's a low evidential threshold. The fact, halfway down 17, those at the requisite, particularly disadvantages are described in the plural persons is the reason why the test is sometimes described as one of group disadvantage. However, the use of this disjunctive, religion or belief, demonstrate that it is not necessary to pitch this comparison at the macro level. Therefore, it is not necessary to establish that all or most Christians or all or most nonconformist Christians are or would be put at a particular disadvantage. It is permissible to define a claimant's religion or belief more narrowly than that. In my judgment, this is where the Employment Tribunal went wrong. It described the claimant's Sabbatarian belief as not a core component of Christian faith. By so doing, it opens the door to a quantitative test on a far too wider basis. And then he goes, it is clear, and if it is necessary for it to have evidential foundation. Lord Justice Morris' case, this whole issue, whether Christians are Sabbatarians, evidence required of group discrimination, we're going too far at the macro level. We can boil it down to the micro level, and we don't even really need much evidence. If you need any evidence, a statement from Nazar Ali will do, but most of this is pretty obvious, and judges act on a common sense basis. And then he goes on at 21.
Yep.
Here's on paragraph 21. Elias and Voss, Lord Justice, take a different view about the relevance of Article 9. Theirs is a more sophisticated for my analysis. For my part, whilst I agree that Article 9 does not carry a requirement of group disadvantage, I prefer not to reading down for convention reasons a domestic provision which is compliant with the directive from which it is derived. I am not convinced that giving regulation free its natural meaning would involve a breach of Article 9. However, I prefer not to go further into this complicated case in which we are all apparent for the disposal.
So that's what I must say. I find that slightly difficult to follow, but that's the minority view. So, except in order to understand the majority view, it's of no value to us.
Well, in some ways, Morris came up to a very practical position. He just simply said, we don't need all this macro evidence. We can, if evidence is needed, we can just proceed on this normally within the directive without having to stretch into the convention.
Well, it would depend on the facts, wouldn't it?
It would.
Some facts you could proceed without very much evidence.
Yeah.
But others might require more evidence in order to get you over the hurdle.
Yes, I think, and it also would depend what the issue was.
Yeah.
I mean, if it's something in an employment business, in this case, Mr. Page expressing his religious views, or in this case, one employee not wanting to work Sundays, that's a very different question about some national measure that may affect numbers of individuals. Elias J. addresses perhaps this bit closer, if I may, at paragraph 34, 35. However, in my judgment, the same analysis does not hold sway where the right to religious freedom under Article 9 engaged, as it is directly in this case, given that the Council is a public body. The protection of freedom of religion conferred by that article does not require a claimant to establish any group disadvantage. The question is whether the interference of that individual right by the employer is proportionate given the legitimate aims of the employer. And he quotes Edwida. In substance, justification is likely to raise the difficulty otherwise of accommodating the religious practices of the particular individual claimant. Article 9 cannot be forced directly in employment tribunals because claims for breach of convention rights do not fall within their statutory jurisdiction, although Strasbourg and Guida does not seem to have appreciated that fact, and that's some of the points we've made. The Edwida decision of Strasbourg has not and could not affect the reach of statutory jurisdiction, and therefore the claimant's Article 9 rights are incapable of direct enforcement in the Employment Tribunal. However, domestic law must be read so as to be consistent with the Convention. where possible, in accordance with Section 3 of the Human Rights Act. In my judgment, it's simply not possible to read down the concept of indirect discrimination to ignore the need to establish group disadvantage. But I see no reason why the concept of justification should not be read compatibly with Article 9, where the provisions in play. And that's what the Employment Tribunal focused on in Page. Well, he says you've got to have group disadvantage. I haven't seen enough evidence. In our submission, reading 34 and 35 conjunctively, Lord Justice Elias is fully aware that Article 9 doesn't require group disadvantage and it's directly effective against the public body, as in this case.
What's that got to do with it? The question is about it's the jurisdiction of the tribunal.
Yes, but our submission is how he dealt with that was he didn't abrogate group disadvantage, but in this case, on these facts, with merely one statement from the bishop, you could go on and consider the proportion.
Well, no, I'm sorry. I don't understand all this. If you look at paragraph 28, there was never any issue about group disadvantage in this particular case. 28, in this case, it was conceded that the provision requiring Sunday working constituted the group disadvantage identified. So the only issue was justification.
Yeah, well...
So, I mean, nobody had to make any view, not necessary to have any views about how it would be proved. It had been proved in the Employment Tribunal and no one was challenging it.
No, but what had been accepted in this case, which was discussing jurisdiction, was the very fact that it took one short statement of the obvious from Bishop Nazarali to move to the actual substantive point, which was justification. We have an
I just don't see how any of this gets gets you anywhere. In Umbar, an employment tribunal on evidence we haven't actually seen, but obviously included the statement from Bishop Nazarali, and perhaps that's all there was, and if so, they obviously found it was enough, have found that a requirement of Sunday working put Christians at a disadvantage, at a disproportionate disadvantage. Fine. I mean, now we've got to see whether the evidence before this tribunal obliged it to find that the PCP, once we have established what that is, which you've jumped right over, but once we've established what the PCP is, whether that PCP put Christians at a disadvantage. And we've got to see what the evidence was and why you say they were bound on that evidence to find that it did.
Well, the evidence was greater than...
Well, it's paragraph 19, Mr. Diamond.
Yes.
It's an assertion and a reference to the Bible.
No, there's more than that, lady.
Well, let's just look at that first.
There is a petition, there is an article written by Bishop Nazarali.
Sorry, in this case?
In this case.
Well, where is that referred
I'm
to?
just trying to find that.
Witness statements are listed at 7. There's no reference to a statement from anybody on the claimant side except the claimant himself.
yes, if you go to paragraph 79 of the judgment. There's a number of documents in the bundle, a petition, press articles, quotes from the former bishop, but these fall quite short. Bishop of Rochester and Michael Nazarelli.
Oh, I see. Well, in law, your submission is that it was perverse for the tribunal not to treat that as adequate evidence. I got this right?
Yeah.
Having regard to that documentary evidence.
Yeah.
Well, the first starting point for that is to show us the evidence in question. That's not in the bundle, as far as I'm aware.
No.
So you don't get to first base.
Well, I mean, obviously, I'm not sure why it needs to be in the bundle. The judgment.
Well, because the nature of an argument, of a challenge to a finding of fact, has to be it was contrary to the evidence. So we have to see what the evidence was.
But
I agree. It could, if it had all been fully transcribed into the thing, we wouldn't need to see the actual bits of paper. But all we know is that there was a petition, and we don't know how many people signed by or what it said, and there were some articles. We don't know what they said. So,
I accept that, my lord. But what that is indicative of the dismissive nature of the judgment, not addressing the issues.
no. Well, maybe it is. But in that case, you must demonstrate by showing us the material which you say they overlooked or didn't give proper weight to. I'm not suggesting you can do it now. I mean, it should have been done in the EAT.
Well, I mean, the Mabar in our submission gives a very low threshold was accepted by the lower courts. It was not criticised by the Court of Appeal. It was accepted. It triggered jurisdiction, and it was an ambiguous statement, which in that case the Employment Tribunal actually took to mean its exact opposite effect. But that was an extremely low threshold. Our case in this is that we accept you haven't seen it. There was clearly a petition related to this. There were various petitions when Mr. Richard Page was removed.
I'm sorry,
Yeah.
but a petition saying we support Mr. Page doesn't equate to we hold a view that adoption by same-sex couples is not to take place and adoption by a man and a woman is always better.
No, but I think, as in the Barn jurisdiction, we're not dealing with a broad-based policy or consideration that would affect thousands. Mr. Page asserts that is his religious belief. Under Article 9, that would suffice to trigger.
Well, is that right? We're not. But we've all agreed we're not dealing with Article 9 because we've got to deal with. On this, on your alternative submission, which is the one you're making, we've got to deal with the fact there is a requirement of group disadvantage. But I suspect what the tribunal was thinking was this. Certainly it would occur to me. I have no difficulty in accepting that very many Christians would believe, as an aspect of their Christian belief, that a child ought to be brought up by a mother and a father. But I would expect that to be also to be the view of many non-Christians, both members of other religious faiths and of no religious faith. And I'm not sure that I would expect the proportions to be any higher among Christians than among the community generally or among other religious groups. Certainly I would need to see that that was see evidence that was so. It doesn't seem to be intuitively right.
Well, this case is essentially one of direct discrimination and or victimisation. So I don't want to get bogged down in it, but I think what I would like to draw to your lordship's attention in this matter is that courts, I've talked about reclassification in the morning, they come up with the term group discrimination, and no one knows whether it requires an Equality and Human Rights report or whether it requires a simple letter saying there are two of us who believe this.
Well, I think it will depend on the case, won't it? Some things you're quite right in saying are pretty obvious, and if you can't get the court to take judicial notice of it, you just get a statement from as it were, a religious leader who can say. Others will be much more complicated and might need to be quite carefully considered.
Well, it does, but I think it's very difficult. I mean, these are individuals coming to employment tribunals making assertions, and our submission is that the threshold should be low. It shouldn't be used to be a barrier to the court considering justification for the policy.
But you keep saying threshold should be low. I think you mean the evidential threshold.
Evidential.
The legal threshold is what it is.
It is what it is.
But you mean it shouldn't be made too difficult to prove? No, well, I see that.
I mean, if you even take the Edwida case, in the Edwida case, there were two cross cases, Mrs. Edwida and Mrs. Chaplin, and both courts held there was insufficient evidence for the group disadvantage point, even though two cases were going forward at the time, and I submit that the evidential threshold should not be excessively.
No, well, we have your point on that, and I do see that.
Yes.
But ultimately, we come back to the question whether the tribunal was entitled to find that the threshold, low as it may be, hadn't been met in this case. You say they weren't. You would like to say they weren't.
I would like to say they weren't.
I think there is certainly the EAT did not understand there to be any perversity challenge before them, which is unsurprising because they weren't given the documents. But there we are. We see how it is. Thank you.
Yeah.
So let me make a note. Right. So let me just stock take where we are. We've had your submissions on direct discrimination in some detail and incorporating submissions on the convention. We've had briefly your submissions on victimisation because you say it's essentially the same as in the magistracy case. And we have now had your submissions on the alternative way which you're of putting the indirect case, indirect discrimination case. I think, subject obviously to anything else you want to add, therefore that we've had your submissions on the grounds of appeal. Is that right?
I think that's correct.
Yes. Well then, thank you. Subject to anything my lord or my lady might want to ask. Thank you very much indeed, Mr. Diamond. Yes, I think we'll hear from Miss Criddle first, if we may, because I think, well, it remains to be seen whether we will want to hear from you on the points specific to your case, but we certainly, I think, want to hear from Miss Criddle on.
My lord, might I ask to swap places with Miss Lady?
Yes, but, if I had been more on the ball, I would have suggested it.
Save my
Well, for two reasons. Firstly, from there you won't be picked up on the live stream. Yes.
grateful, thank you. So it might just be worth making one clarification of fact at the outset relating to who the respondent is in this case, because on multiple occasions people have referred to the respondent as the trust. Yeah. The respondent, strictly speaking, is not the trust. It is the Trust Development Authority, which has the statutory function for the appointing and the removal of non-executive directors from NHS trusts. Maybe that nothing much turns on the point, but I can almost feel
you're
my
quite right to remind me, at least I was aware of that. Yes.
Thinking that that's not us.
But can I ask a very pedantic point arising out of that? I think the EAT says, or someone says somewhere, that the trust was originally a respondent but dropped out.
Yes.
And I actually looked at the ET one and I couldn't see that was so. There were originally 2 respondents, but the other one was the Secretary of State for Health.
There were in fact, my Lord, 2 separate claims. There was a claim against the Lord Chancellor and the Lord Chief Justice.
Oh, well,
and
that
there
of
were 2
course,
respondents
yes.
in that case. But in the appeal that concerns us now, the claim was originally, I think, brought against both.
Let's just. Perhaps it's boring, but it'll have to be got right in the judgment. So I wouldn't mind just clarifying that. If you the claim form in your case, if I can call it that,
yes,
is at page 339.
It is, and I see my Lord's point, because it refers to the first respondent, the Secretary of State for Health,
and the second respondent is the authority,
the NHS Trust Development Authority.
And as far as, if you were only looking at that, there may be some little bit of interlocutory history that we haven't been troubled with.
There may be, but what one certainly sees from the interlocutory history,
yes,
the tribunal judgment, they do say that the trust had been involved and then dropped out of the picture. Yes, that, my Lord, it's page 294, paragraph 11.9.
Yeah, well, that's what I saw and puzzled me, because either that's a mistake by the tribunal, or at some point the trust did come in and then came out again, or a third possibility, although the Secretary of State was named, that was meant to be the trust.
All of these things, my Lord, are possible.
None of it deep down matters, except it matters to get things right. Could I ask you overnight to clarify that for us?
I will certainly take instructions and find out what the status of the trust was in terms of how it came to be a respondent, if it was a respondent.
Yes, I think first question is, was it ever a respondent?
It looks as though, I'm so sorry to interrupt, page 353 is the ET3. At paragraph 10, the ET3 says that Mr. Page was removed by the TDA on behalf of the Secretary of State, so the respondent is either the Secretary of State or the TDA. So I suspect the trust didn't become involved, and that's a mistake, but anyway.
Because precisely for that reason, my lady, the trust would never be the appropriate respondent, because it does not have the power either to appoint or to remove a non-executive.
Well, absolutely. I quite understand. I think the only correct defendant throughout was the authority.
Indeed.
But I just wanted to iron out this wrinkle of who the other respondent was.
Of course.
And there was a time, but I think long before any of this, where the whole NHS in law was the Secretary of State. But that was 20 years ago. I think trusts have legal personality. So, okay.
And so, moving on then to the substance of the appeal involving the Trust Development Authority. The appeal involving the Trust Development Authority is rather broader than the appeal involving the Lord Chancellor and the Lord Chief Justice, because there are 3 separate claims which are being challenged by this appeal. One is the rejection of the case on direct discrimination, then on victimisation, and then on indirect discrimination. I propose to take them in that order, because that is the order in which you heard submissions from Mr. Diamond in relation to them. But one thing that may have struck the court, it certainly struck me, when one looks at the opening paragraphs to the skeleton argument, which we now understand to be adopted by Mr. Diamond, where it says this, and it's page 202 of the court's core bundle, and at paragraph 1.
Just give me a moment. Oh, wait a minute. So sorry. I thought I was in the wrong bundle. I was in the right one all along. 202, yes?
202, paragraph 1. This case, the author writes, involves the removal of an office holder for the expression of religious views in a non-work-related forum. It raises the question of whether the Equality Act is able to prevent discrimination against religious and philosophical speech, as protected by Articles 9 and 10 of the European Convention on Human Rights, is given effect by Section 3 of the Human Rights Act, and Articles 10 and 11 of the Charter of Fundamental Rights is given effect in Article 6 of the Treaty of Europe. But that is not, with respect, what this case is. We know that the Equality Act is capable of preventing discrimination against religious and philosophical speech. We know that the Equality Act does that where that speech is found to be a manifestation of religion or belief. That falls within the ambit of Section 10. And we also know that the Equality Act protects that speech where it is found that the treatment of that speech is discriminatory in the sense defined by the Equality Act. So one needs to find direct discrimination, less favourable treatment than someone not sharing that religion or belief, or there is indirect discrimination, the application of a provision, criterion or practice, putting those of that religion or belief at a particular disadvantage, or where there is victimisation because of what has been said. But it is not a case philosophically, if I can put it that way, about whether it's possible for the Equality Act to protect religious speech. What this case is, in my submission, is a decision on its facts, and a decision on its facts that went against the appellant for perfectly permissible reasons. And there are important and unchallenged findings of fact that the Employment Tribunal made. This is not a perversity appeal in any way, shape or form. And if I may, I would like just to look briefly at some of the important findings of fact that the
Is this before you get on to direct discrimination, or are you at the moment dealing only with direct?
If I may, what I wanted to do was to put these submissions on direct victimisation and direct in context by reference to the findings of fact, because then when I come to make submissions on each of those grounds, they'll be informed by those.
Yes. No problem at all. I just wanted to see what the structure was. Yep.
And so the decision of the Employment Tribunal starts at page 290 in the core bundle. And at 292, right at the top of the page, there is a heading, Documents, Evidence and Findings of Fact. And then at paragraph 11, in light of all the evidence read and heard by the tribunal, it has made the following unanimous findings of fact. So sometimes Mr. Diamond says, well, it's not clear when it was making findings of fact. I say that is wrong, because it's clear that when we are in paragraph 11, these are the findings of fact of the Employment Tribunal. And at paragraph 11.6, page 293, there was an acceptance by both parties in evidence that lesbian, gay, bisexual and transgender, abbreviated to LGBT, members of the community suffer disproportionately from mental health problems. Both parties also accept that there have been significant difficulties with a lack of willingness on the part of LGBT members of the community to engage with mental health services, such as those provided by the Trust. And then they go on at 11.7 to say that the trust and the respondent see it as vital that its staff and board should not do or say anything that could be perceived as giving rise to a risk of losing the confidence and trust of any section of the community it serves, including those such as LGBT individuals where there has been historic distrust and difficulty of engagement. The claimant accepted that it was vital that LGBT members of the community should feel welcome in the trust and should be encouraged to access its services if they need them. And I pause there because some of the submissions you heard by Mr. Diamond might lead you to the conclusion that this was all about almost a contest between two groups of views, as I think my Lord Justice Peter Jackson put it. But that was not what the concern was. It wasn't a concern that LGBT individuals might not like Mr. Page's views, but about the impact on their willingness to engage with the trust and to seek services that the trust was able and willing to provide. At 11.8, there is reference then to the trust's equal opportunities policy. And the claimant, and this is just 2 lines above 11.8.1, the claimant accepted that the standards expected of him included requirements to 11.8.1, uphold the provisions of the Equality Act that prohibits discrimination on grounds of sexual orientation, including in relation to adoption. And then point 2, promote equality for LGBT members of the community. Point 3, resolve any conflicts arising from his personal interests, including his religious beliefs, that could influence or be thought to influence his decisions as a board member. And pausing there, that is the point that my Lady Justice Simler raised this morning, in relation to the Lord Chancellor's appeal, was the expression of view by Mr. Page that effectively he would be biased. He would start from a preconception in relation to his decision making as a magistrate, and that was also a feature of the TDA case.
Are these direct quotes from the policy, or, well, you weren't there, I appreciate, were they matters that were put to him as it were, consequences of the policy which he accepted? If you don't know, that's fine.
Well, the direct answer, my Lord, is I don't know, but it is, I can do no more than say the claimant accepted that the standards expected of him.
Yes,
so
no, well, I see that.
It was either the policy or it was based on the policy, and this is what the claimant accepted. And then at point 4, act as a role model within the trust. Point 5 is to reflect on how his behaviour may affect those around him. And point 6 was to support and follow reasonable instructions from the chair of the trust. There is then a fairly long section dealing with the interaction between Mr. Page and the Lord Chancellor and the Lord Chief Justice, none of which involved the TDA at all. The TDA didn't even know anything about it. But then at 11.19, page 295, there's reference there to the events of the 3rd of February 2015 when the Trust received a formal complaint by email concerning the claimant, including as to his press and radio interviews. The complaint was from the chair of the Trust's LGBT network. It referred to the views expressed by the claimant in the media and said that, quote, this opinion is highly offensive to same-sex parents, and if nothing is done about Mr. Page's statements, then the Trust will be seen as complicit with that attitude, and that it would be highly damaging if the LGBT community and society in general were to see the Trust as harbouring this type of opinion.
Narrative begins at 11:16, doesn't it? So far as...
Yes, my Lord, you're right, of course, that is the chronology of events, because effectively the Trust learns almost all at the same time about the fact of the media interviews and then the complaint from the LGBT staff network. What then happens at 11.20 is Mr. Ling, who is the chair of the Trust, arranges to meet the claimant again with the Chief Executive, and a further meeting takes place. The claimant confirmed his view that children needed a mother and a father, and that he stood by that view. The claimant was asked to give an assurance that he would not express his views in a public forum, but he would not give that assurance. He did, however, accept that he should have told the trust about his contact with the media. And then at 11.21, there was some further correspondence. Mr. Ling reiterated that it was the claimant's public expression of his views in the media that could undermine confidence that he would exercise his judgment in a way that was not affected by those personal views. There's then reference to a letter from the claimant dated the 12th of March that he was sorry that there had been an impact on the trust. He apologised for any problems he may have caused and confirmed that his actions, discussions and decisions within the trust would continue to conform strictly with the trust policies and
I think
standards for NHS.
both to save your voice and the rest, if you're just going to read out great chunks of this, which I terribly encourage, I think it's easier to ask us to read the paragraphs to ourselves.
Of course, my lord, I'll bear that
But
in
of course,
mind.
if there are literal particular phrases you want or sentences you want to identify, then you please do.
But the point I just wanted to make by reference to those paragraphs, and it matters in the context of the reliance placed on Ngole, and I think my Lord Justice Underhill put to Mr. Diamond that really Ngole is all about a case about disproportionality, that these factual features of this case are very important in assessing the proportionality of what happened, because effectively the first time it happened, if I can put it that way, the trust did not approach the respondent with a view to the removal of Mr. Page from office. That there was a process of trying to discuss matters with
It's an oddity about this case, is it not, that in fact, on the way it has been decided throughout the issues before us, there is in fact no issue of proportionality. I don't blame you for making the points you do, because they meet some of the points made by Mr. Diamond. But if this is direct discrimination, proportionality doesn't come into it.
Yes.
Indirect discrimination was decided, for better or for worse, on a point about group disadvantage, and the tribunal said nothing about justification. And I don't think that was ever raised by respondent's notice, was it? So that's not open to us.
Forgive me, my lords. There is
it might have been open to the trust, the authority, I should say, to say, by the way, although we won on group disadvantage, to say in the EAT, we wish to uphold the decision on a different basis, namely that it was clearly proportionate.
Yes.
And I'm right in saying that route wasn't taken, was it?
Well, there is a respondent's notice before this court, my lord, in which the TDA says, and if you bear with me one moment, the page 200. At 200 ground 2, indirect discrimination, paragraph 2.
Oh yes, you're quite right. I am sorry, I hadn't picked that up. It's 3.3.
Yeah.
I should have done. You'll develop that in due course. But that's at any rate a short-term answer to my point that actually we never get into proportionality, but we could.
We do, I think, my lord, get into proportionality. Well, you get into it directly, certainly by reference to the indirect discrimination claim. Mr. Diamond would say you also need to get into an assessment of proportionality by reference to Article 9
yes,
of the Convention. So,
but on your case, we don't really, do we?
Well, I would say not, because it seems to me that given the concession made this morning by Mr. Diamond in response to the questions from Lady Justice Simler, there's no challenge to the legislation, and that actually Article 9 and Article 10 add nothing to the analysis. That needs to be
well, I thought that was your position. Okay, well, I'm sorry, I've distracted you. Anyway, you were making points about proportionality.
But that was. Yep. But as I say, just to put in context the submissions I'll make, that is why I refer to the decision. And if you just bear with me. And then what one then sees, and I'm going back to page 296, and I'm now at paragraph 11.22. one sees that the trust had reported what had happened to the respondent, but there'd been an instruction by the chair to the claimant to inform of an immediate interest and was taken no further at that stage.
Well, you're really just, aren't you just, we have read this and we are pretty familiar with the facts. Of course, please emphasise points that go to proportionality, but just telling us what happened isn't really necessary.
Is the short point that having written a letter of apology, unbeknown to the trust, the appellant went on television the same day.
Yes.
Then there was a hiatus while the proceedings relating to the Lord Chancellor worked their way through. The result of those brought the further opportunity for publicity, and the trust or the authority then got re-involved in the wake of that. But that was it all went quiet so far as the TDA was concerned between those two periods.
My Lord, yes, and therefore to short circuit this, page 298, paragraph 11.35, is where the tribunal accept the respondent's reasons as to why there'd been a suspension of the claimant, and they set out the reasons for it at 11.35. Its engagement with the media, likely consequent impact on staff and patients, and the failure to keep the trust informed. And then finally, on the facts at page 300 at paragraphs 11.42 and 11.43, the tribunal deals with the reasons for the what's called the TAP, the Termination of Appointments Panel's decision. They ultimately make the decision on removal. They refer to, and this is 5 lines down, the letter centred on the claimant's public response to the decision, the events following, their conclusion that his position was likely to have a negative impact on the confidence of staff, patients and the public in general. It then refers to the concern that the claimant failed to accept that statements made in public might impact on his credibility as a non-executive director, failed to accept personal responsibility, and to just demonstrate insight. And then there's 11.43, apparent inability or unwillingness to distinguish between personal views and what's appropriate as someone, a non-executive director with a high profile, to say to the press and other media. And then there's reference to active engagement with the media and it being compounded by failing to follow the instruction. Forgive me for labouring the point, but quite a lot has been said to this court by Mr. Diamond about there being a lack of clarity by the tribunal, a failure by the tribunal to engage with the evidence, a failure by the tribunal to make findings of fact. That, I say, is simply not right.
Well, there is an oddity, though, isn't there? I'm grateful to be reminded of that. I've just flicked my eye over the letter itself, which we've got in the supplementary bundle.
Yes.
Some of the features that appear in the letter and are recited as facts here, simply as this is what the trust said, are not actually picked up later on in the discussion. For example, loss of confidence by staff, or failure to appreciate that he'd done anything wrong.
Or the not mentioning the JCIO inquiry.
Or not mentioning the JCIO inquiry, as my lord says. I don't know whether that's, I'm not actually sure that was what Mr. Diamond had in mind, but this may not in any way be fatal, but it would have been very straightforward for the tribunal simply to say, we find everything in the letter was reflected the TAP's actual decision.
Yeah.
They didn't actually do that. I don't know if it was deliberate or just bad drafting.
And it may have been preferable had they expressly said, we find that the reasons for the action were everything that we've set out at paragraphs 11.42 and 11.43. But certainly when the EAT comes to look at this, they say, well, actually, you can pick up the thrust from, I think we'd identified earlier on, that it's 52, 55 and 57.
Well, but even that doesn't cover all the points made in the letter.
Well, it may be that there's some shorthand being used. For instance, at 52, when we talk about the manner in which the claimant expressed his beliefs, that might be said to encompass quite a lot.
Well, I'd be quite interested to know what you said that I was going to wait till you got there, but it is now a good moment. And what do you think it was meant by the manner in paragraph 52?
Well, I think...
Or to submit, I should say.
Yes, quite. It may be a convenient point at which to deal with it. When one looks at the manner, it seems to me, or I would submit, that the manner encompasses two things. One relates to the public way in which the beliefs are expressed. Because it said occasionally that this is views in the press. Well, actually, it is courting press interest or being receptive to press interest, certainly.
Well, hang on, I think we need to unpack that. Those are three separate things. One is going on telly,
yeah,
if that's the manner, television, I should say. Two, courting press interest, which is much more active, and three is somewhere in between, being receptive to press interest.
Yes. Forgive me, I don't think I can put it as high as saying courting press interest, because I don't think that there is a finding to that effect by the tribunal. But I think I can certainly put it on the basis of being receptive to press interest.
Engaging actively is the way the tribunal described it.
I'm grateful, my lady. So that I think is an aspect of the manner. And then, of course, there is what is said, not in the sense of an expression of a religious belief, but what is said in respect of a unwillingness or an inability to distinguish between your own personal views and the role that is required of you in public life. It is the, and I hesitate to put it in this way, but almost the preconception point. It is giving rise to a perception that you will approach your decision making in public life with preconceptions about people and about what people should or should not do because of who they are. And that, in my submission, encompasses the manner.
Sorry to be over pernickety. I understand inability to distinguish between your own views and what is required of you in a public role.
Yes.
You could argue about whether that naturally comes under the word manner, but I understand what you're saying. But then three, the point you then went on to make about preconceptions, that's really a different point, isn't it? Or have I misunderstood it?
Well, I don't think, my lord, it is a separate point, but if it is a separate point, it's very closely associated with the previous point that I made. And I'm looking, and it may be helpful to pick it up from the judgment at page 317, paragraph 57. This is part of the tribunal's analysis about interference with Article 9. But the tribunal does say, the very last line in the tribunal's judgment, the claimant's actions were clearly in conflict with the protection of health, the protection of the rights of others. There's reference to the public sector equality duty and to specific issues with mental health problems, and a specific and genuine concern as to the impact of the claimant's actions, and that was justified. And then there is this: the claimant himself confirmed in evidence that although he did not think about the effect of his public statements on others, even after Mr. Ling had raised it with him in early 2015, he accepted that those reading, listening to or watching his interviews might have made a connection with his role with the trust and or in the NHS in a wider sense, and that could be damaging for the trust or the wider NHS. So that point, that the preconception point, that here is somebody.
Whose preconception are we talking about?
The appellant's preconception.
What's at stake here is not a finding of fact that he would behave in an inappropriate way.
No, certainly not.
As a result of his personal views. In that sense, I take out the word inappropriate as being pejorative, but in that sense, this case is different to the Lord Chancellor case. It's about not his preconception, but the impact of his beliefs, publicly expressed, on other people. So, encapsulated in specific and genuine concern on behalf of the trust,
yep,
about the community. Now, there are various bits that need to be filled in. One of the things is that, as far as I have understood it, Mr. Page didn't appear on television in order to pick a fight with the trust, and he wasn't there because of his role within the health service, nor was he identified as such. Is that right?
My lord, I think that is right.
I had picked up somewhere that he was identified as a senior health service manager,
I think,
but
my lord,
the
I think
specific
that's right.
trust
The
wasn't
specific
identified.
trust was not identified, no. But
Was that as a result of a previous occupation of his, rather than his NED status?
I'll find the reference in due course, but I think that is right. There is certainly reference to him in the health context. Just bear with me. Yes, I think my Lord Justice Underhill may have in mind 11.13, page 295.
Of course, that's about the earlier interviews.
That's the first interview to the Daily Mail, and there is the Tribunal notes that the online article refers to the claimant as an experienced NHS, thereby making a link to the NHS, albeit not specifically to his work with the trust. I think that is the only.
Yes, and of course, by the time
to the
that was those were not. That was a year ago. That was a year ago at the
Yes.
time of the authority's decision.
indeed.
We don't. We can't really go beyond the findings. But if we look just at 1129, there is nothing to suggest that the public were told he was worked in the NHS, still less worked for any particular trust.
Accept that, yes.
And the reference to a senior manager relates to his career as a direct employee for many years, not to his position as an ED.
It may do, it may not. I don't think that one can extrapolate from the reference to senior manager whether that means a manager in the sense of being an employee or a manager in the sense of being a non-executive director. I take the point that one might think that manager more naturally refers to his employment history.
Well, 20 years as an executive director.
But it's not explicit in that way. But to return to the question that was put to me, which is whose preconception are we talking about
Yes.
in this case? I accept that nowhere is there a finding by the Employment Tribunal that Mr. Page would discriminate
I know.
against
The case you're
anybody. I
meeting
accept
is
that.
that it's other people's preconception about him.
There is a concern that he is not able to distinguish between his views, his personal views, and what it's appropriate to do in a public office. And therefore, whether that is a question of his preconception or other people's preconceptions about him, the concern that arises is that this is somebody who may not exercise his functions as a non-executive director in a wholly impartial, non-partisan way.
Whose concern?
Specifically, my lord, that there is a concern that, to break it down, the specific concern that has been identified, well, there are in fact, two specific concerns that have been identified. One is the concern that is expressed by the LGBT staff network. The LGBT staff network do raise directly the concern about bias.
So that's their concern.
That's their concern. There is then separately a concern that the trust has, and by extension the respondent, which is a concern about engagement. That's the broader health issue.
Sorry, we've used engagement in two senses. You don't mean him engaging with the press.
No,
forgive me. You mean potential patients.
That's absolutely right. The potential engagement of patients, people seeking to use the services of the trust for mental health purposes. But an ingredient in the mix is the concern, which is directly expressed by the staff network, that one might think, whether that is right or wrong, that Mr. Page would not approach his decision making in a neutral way because he's expressed views.
Right, that's their view. We know that there are other people signing petitions who've got very different views. How does this impact on the state of mind of the employer?
Well, to deal first of all with the petition, I don't think that the petition says we think there isn't any problem here. We don't think that there is any problem with bias. The petition, as I understand it, is a sort of a broader statement of support for Mr. Page. I think that the broader point of my lord, which is the point I think that Lord Justice Underhill was canvassing with me, is what is meant by the manner in which Mr. Page engages with the media that forms part of the reason as to why my client, the TDA, ultimately removes him from office. And that is where one sees, in my submission, directly the concern that what he says impacts on the trust's ability to engage with members of the public, and specifically LGBT members of the public, and that concern arising because it might be thought that Mr. Page, and by extension the trust, would not approach the LGBT community.
Well, I mean, these are important points, and probably ones we ought to postpone until tomorrow, but they're nothing to do with manner, are they? And maybe we shouldn't get too hung up on I mean, the obvious point
yes.
is that manner would mean something like he was abusive, offensive, and all those things which everyone agrees he wasn't.
Quite.
And that may just be a slip by the tribunal, to use that
Or
phrase.
going on television.
Yeah. Going on television.
Well,
Because that's
but isn't
an
that
awful
is
lot
what
of
they're
people.
talking about.
yeah, we'll all have to go away and read it. Read again what they said. But my slight worry about this part of the case is that the inoffensive word manner does slightly plug into a whole line of cases like Martin, which aren't really relevant. This isn't a case in which he said what he said, which he was entitled to say, but could be dismissed because of the manner in which he said it. And I think it's a bit of a distraction if we use that phrase. It's only because, in particular, I think the EAT picked it out as part of the reasons that I think it's worth spending a bit of time on working out what it means.
Of course.
Well, I think we might rise at this moment. Is it a natural break, or would you? Is that nothing you're bursting to say?
I'm very content if you wish to rise now and pick up where we left off in the.
You've obviously got a bit of ground to travel, but we're going to finish comfortably within the morning.
Oh, well, certainly.
Yes. Thank you all very much. 10:30 tomorrow.
All right.